Welcome, class, to week 5 of contracts. I'm sure that you are super stoked to get this done and over with, right? Well, this week we need to talk about chapter 8. But before I get into that, here's a few reminders. Don't forget that you have a final exam essay due this week, as well as your final exam due by 11:59 Central Time. Also, I want to make sure that you know where to go if you need help. There are highlights in your book. There are videos. There's the discussion. There's a review sheet for this week for final exams. My suggestion, I would take the review sheet, go into the book, note what page each item is on so you can utilize your book during your final exam. Totally make this worth it, all right? It's anywhere between 20 and 30% of your grade, which can really, really benefit you or really, really hurt you. So I really just want you to do the absolute best that you can. So please utilize all of the tools that you're given to do a super great job. And don't forget to reach out to me. I don't bite, I promise. You can text me, you can email me, but I would say during week 5, text me. 419-343-5170. It will give you the quickest answer. Okay, let's get right into this. So chapter 8, we are expected to live up to our performance obligations. And if these obligations aren't met, or somehow excused, then it can result in what we call a breach of contract. So what does it mean to breach a contract? Simply put, one party fails to perform their duty under the contract. Now, the rules of performance and breach of contract are actually rooted in common sense. And honestly, most contracts are completed legally, and both parties have lived up to their obligations. However, breach is found when the law does not excuse a failure for the performance of the contract. And again, we are expected when you sign a contract to live up to that performance. So if those obligations aren't met, breach of contract is the result. So we're going to talk about breaching of contract in relation to how much of a contract has been completed or performed. So the 3 areas that we're going to look at, the 3 levels of performance, are complete, substantial, and inferior performance. So complete performance. So most contracts are actually terminated by complete performance. So both parties have done what they were supposed to do by contract. So at the end of the contract, there are no more obligations. It has been fully performed on both sides. Sometimes this is also called an executed contract. If you come across the term executed, you might want to know in what context the word is being used. When I worked in contracts in corporate, when we say a contract was executed, we actually meant, was it signed? But in most cases with contracts, it means the contract has been fully performed. The next type of performance we're going to talk about is substantial performance. Another term for substantial performance actually means minor breach. So this occurs when there's been a minor breach of contract. In other words, it occurs when a party to a contract that deviates slightly from a complete performance. The non-breaching party may try to convince the breaching party to elevate his or her performance to actually complete it. So for example, if the breach was not material or intentional by any means, then the non-breaching party can sue for damages, but not to rescind the contract. So let's say we have a $100,000 house, and the general contractor put in the wrong doorknobs. The replacement cost is about $100 for the doorknobs. So the courts would say the original contract can still be enforced, just not the doorknobs. Now, on the other hand, if we compare this with a house that has no doors, pretty silly, but if it didn't, there's a failure to provide those doors could be seen as a partial performance because it lacked security by not having the doors. So it was material. The non-breaching party can then sue to have the contract rescinded or taken back and recover damages. So really, what would this look like in real life? Well, if we take the $100,000 house with the $100 doorknobs, then they may work together and deduct the cost to replace those doorknobs from the original contract price. Seems pretty fair. However, the house with no doors, they may have to sue the breaching party to recover the cost to repair. Because if they have to hire somebody else to install the doors after they've already paid $100,000 for the house, it can get pretty messy and pretty ugly real quick. Inferior performance is what we consider a material breach, something very substantial. So when there has been an inferior performance, the non-breaching party can actually rescind or cancel the contract and seek restitution for any monies that were paid under that contract. Or they can just sue the breaching party, treat the contract as if it's still in effect, and recover damages. So there's a couple ways that they can go about taking care of it. So let me give you an example. Suppose Ashley's Dress Shop, Inc. has a contract with the manufacturer for $25,000. Ashley sends the manufacturer the $25 and obviously is expecting to get their dresses back. Well, when the manufacturer fails to deliver the dresses, Ashley can sue for the breach of contract. The other way they could go about it is if the manufacturer says, you know, I still want to have this contract with you. We're back ordered on this. What if we send you this dress and on top of it, we'll send you the other dress once it comes in. And then it leaves out the whole suing part. But there was a breach of contract and they do have a right to sue. So in summary, there are 3 types of performance that have legal consequences if something has been breached. Now, if there's a complete performance of the entire contract, then the contract is just discharged. It's like it doesn't matter anymore because both parties have actually completed the work. The substantial performance or the minor breach or partial breach in some areas, it's a breach of contract that's less severe than the material breach. It gives the harmed party the right to sue for damages, but it doesn't excuse them for further performance. However, the inferior performance or the material breach, this is a substantial breach of contract. That's the sending $25,000 and not getting the dresses, right? That's a pretty big deal. And it doesn't excuse the harm party from being sued. However, the courts may say, you know, it might be better to just take back the contract. There's no longer a contract between these 2 parties. So this next term, anticipatory breach, isn't really about performance, but it's when one party tells the other one that they will not or cannot perform their contractual duties. So the non-party's obligations are immediately discharged. As an alternative, though, the non-breaching party also has the right to sue. So for instance, let's say I build cabinets for a living and I was going to supply for a hotel. And so I get into a contract with the general management at the hotel. And the general manager has to bring in all of these subcontractors to, make sure that everything is done correctly for the cabinets. And then the day comes in, he assumes they're going to be installed, and we call him up and say, hey, we're not going to be able to meet your demand. We're not going to be able to meet this contract. So even though there's not going to be a contract, that non-breaching party, that hotel, they were probably harmed because every day that they're closed down means that they're not bringing in any sales. So the non-breaching party, or the hotel in this manner, has the right to sue the other party immediately, and they don't have to wait until there's actually a performance not done. So a consequence of contracts having breaches is that the non-breaching party can recover money damages, whether the breach was minor or material. And that's what we're going to be talking about, is we're going to be talking about remedies that are available for the non-breaching party. And if you think about it, it can be compared to various directions posted on a map when your car's broken down. Because your trip has been brought to an abrupt halt, you may decide which options make the most sense to you. Do you try to get back to where you started? Can the car be fixed where you are? Do you need a tow to your original destination? So contracts is the same way. There's going to be all these different avenues. It kind of just depends on what you want the ultimate outcome to be. So let's talk about compensatory damages. This is actually pretty easy. This is the actual damages. So this is an award of money, and it's intended to compensate the non-breaching party for the loss of the contract, or the damages of the contract. Remember the $25,000 dresses? Well, what if the dresses were for some big gala or some big show? They may be able to also get the ticket prices. They may be able to get the price of the dresses, the shipping, and other damages. And so this is to repair the non-breaching party, to help get them to where they would have been if they would not have gotten into contract with somebody. So again, this is actual damages that somebody has suffered. Now, that amount will be rewarded depending on a couple things. One, the type of contract that's involved, and which party breached the contract. So for example, if Jack had a deal with Fried Motors to buy a new car for $20,000, but had to buy a comparable model from Fox Motors at $30,000 due to Fried Motors breach, the actual measure of compensatory damages would be $10,000, because Jack was already planning on spending the $10,000, but he was forced to pay $30,000 so he could sue Fried Motors for that $10,000 that was actual damage. The special types of contracts: sales of goods, construction contracts, and employment contracts. So for the sale of goods, under the UCC, the usual measure of damages is the difference between the contract price and the market price of goods. Kind of like in our example with Fried Motors. In construction contracts, the recoverable damages really do vary depending on the construction contracts. It depends on the stage of completion of the structure at the time of breach. So it's going to be different if it's at the time that the whole entire house is built or the whole building is built versus if it happened in the first stage. And as it relates to employment contracts, breaches of employment contracts will allow recovery of lost wages or salary as compensatory damages. Mitigation of damages. So a non-breaching party has a legal duty to avoid or reduce any damages caused by a breach of contract. So Just because the other party breached it doesn't mean that you have the right to make it worse. And that's essentially what this is saying. They have a legal duty to keep it as minimal as possible. So when a person suffers damages as a result of breach of contract, they have to minimize those effects. And how do they do it? Anything that can be reasonably avoided and they can recover for, the courts rather them do it that way. Consequential damages. Kind of my favorite kind of damages because it's all over the place. This is also considered special damages. I have an example for you. One of my first times in the contracts department, it was pretty interesting, and it was in my first month or two that I was there. But the company I worked for was being sued by a developer for consequential damages. And what the company had to pay out was a pool for each of the new homeowners. Why? Because our shipments were not correct, and the style of cabinets that were supposed to go in them were the wrong ones, but they had already been put in. And so it would have cost way too much money to take out all the cabinets and put in the new ones. And the developer was trying to figure out a way to make the homeowners happy. So with 100 homeowners, they thought, well, this would be a good deal. Each one of them gets an in-ground pool. Well, that fell through. We never really had to pay out the pools. But that was the type of consequential damages that this developer wanted us to pay. So they're special, right? They are reimbursements in civil court for the breach of contract. Liquidated damages. So liquidated damages, which by the way is the provision that you're supposed to be writing in your assignment for this week. So when damages are too difficult to try to figure out in advance, parties may agree to what they call a liquidated damages clause. And for example, construction, especially construction of bridges, railroads, anything that has to do with public transportation, they may have a clause in there that says any time that this is delayed due to this party's issues. So for whatever reason, we don't have the parts to get out there, or I don't have the manpower to get out there, then because this contract will say you may have to pay $1,000 a day or $5,000 a day. Some of these contracts I have seen up to $15,000 a day for a delay. So we don't get our parts there in time, we don't get our people there in time, automatically a bill for $15,000. Now imagine there's some sort of transportation issue and it takes a week, or there's a permit issue and it takes 2 weeks. This could really add up pretty high. And so it's money damages essentially, but they're made ahead of time. All right, nominal damages. So you'll see these in not just in contracts related, but in really big lawsuits as well. So this nominal damage is about a principle of an idea. It's not about the award of money. So you'll often see these in very large lawsuits, medical lawsuits, where they know perhaps somebody was killed because of some sort of transplant or a medical apparatus that has gone wrong. And so there's this big, huge lawsuit. And really what the family wants is for the facilities to say that they were wrong. and to admit that they were wrong in court. Now, the award for nominal damage may be $1, but that wasn't the point. They know they can't bring the person back. They want the hospital, the doctors, or whomever to admit that they did wrong. And so they use this nominal damages. Now, usually, this isn't all they're going for. This is just one of them. Because then what happens is if they can prove that the other person was wrong off of principle, then they can generally tack on what we call punitive damages. So if it's a jury trial and the jury is the one who can make the punitive damages, maybe they won nominally for $1 or $100, but the punitive damages, which are what we call punishing damages, they may get some astronomical amount, like it's $500 million or it's $1 billion or whatever the jury believes that a person's life is worth. All right. So now we have a breach of contract. And we know the types of performances, we've gone through those, we know that there's remedies. So what happens if the breaching party refuses to pay the court-ordered judgment? Well, the court can do a couple things. The court can order a seizure of property. They can do a writ of garnishment against wages or even bank accounts. So just because the breaching party doesn't want to pay doesn't mean that they won't pay. Real quickly, I just wanted to talk about the two terms, rescission and restitution. When we've used rescission in some of the previous slides, it's just an action to undo a contract. Take it back, if you will. And that's available when there's been a material breach of contract, a fraud, any kind of undue influence, or even a mistake. Restitution, that would be returning the goods or the property received from the other party to rescind a contract. So if we take our dress scenario and the one party sent the $25,000 to get all the dresses, well, in that case, the actual goods or the dresses couldn't be sent. And so the contract essentially needed to be rescinded, right? Canceled. So the breaching party would have to send back the $25,000. Did you know that a wedding ring must be returned if an engagement is broken off? It's true. Contemporary courts generally hold that engagement rings must be returned to the donor, that's what they call them, no matter who breaks off the engagement, because the contract was broken. All right, let's move on to equitable remedies. So equitable remedies. This is for specific performance, and its reformation and injunction are available to prevent what they call unjust enrichment. So equitable remedies are a distinct category of remedies, and they can be obtained in a breach of contract situation. In general, remedies can be divided into two categories, legal and equitable. You might be asking, what is unjust enrichment? What does that mean? Well, this can occur when one party begins providing goods or services with the expectation of being paid, only to discover later that the other party refuses to pay for the goods. Unjust enrichment. All right, so specific performance. This is basically a court order which requires a party that's in breach to completely perform their part of the bargain according to the contract. For example, this can include requiring the breach party to deliver goods which have already been paid for, or to render payment for services that they didn't pay for. Reformation. Contract reformation. So it's rewritten. The contract is actually rewritten in a manner that reflects the true intentions of each party more clearly. So if we go back to the dresses, and the one party sends the $25,000. And the manufacturer says, look, we don't have those dresses, but I can provide you with this set. Let's rewrite the contract so it expresses our true intentions, which can be done. Now, the remedy of reformation requires that a valid working contract was already in existence, or otherwise there'd be nothing to rewrite. And reformation is often prescribed where maybe there was a mistake or a misrepresentation, for example, the dresses, in one of the contract terms. So a contract may be reformed or rewritten in whole or in part. Sometimes reformation is also called rectification, but is mostly caused due to clerical errors. An injunction. This is simply a court order that prohibits a party from doing a certain thing. Torts associated with contracts. Now, if you haven't taken tort law, no worries there. Just know that torts is a lawsuit, a civil wrongdoing. Somebody was harmed civilly, right? This isn't a criminal law. It's just a civil lawsuit that can be associated with contracts. So torts associated with contracts, if a party can prove that a contract-related tort, they can recover certain damages, including compensation for personal injury, pain and suffering, emotional distress, and possibly punitive damages. Remember, I said earlier, punitive damages equate to punishment damages. So intentional interference with contractual relations. All right, so this is a tort or a lawsuit that arises when a third party induces a contracting party to breach the contract with another party. What? So this can actually happen quite often in sales. Now, in order for this to hold up in court, the third party has to intentionally, right, and interfere. And that the contract must have been valid, so there has to be one already in existence. The defendant, the third party, had knowledge of the contract, and that the third party acted intentionally and improperly, and then that the plaintiff was injured by the defendant's actions. And lastly, breach of the implied covenant of good faith. Wow, sounds really complicated. It's not. So in contract law, the implied covenant of good faith and fair dealing is a general presumption that the parties to a contract will deal with each other honestly, fairly, and in good faith, hence the good faith. So they're not destroying the right of the other party or parties that receive the benefit of the contract. And parties to a contract are not only bound by all the terms that are in them, but that we're going to act in good faith. Breach of this would be called the tort of bad faith. All right, so that's the end of chapter 8. I know it was long. I don't think it's as bad as last week's information, but can still be complicated sometimes. Ultimately, if you can get a broad understanding of contracts, it will really serve you in various parts of the law. If you decide that you're interested in contract review, it is a subspecialty in the paralegal field, but don't think you're going to be expected in your first month of being a paralegal to draft an entire contract. It's not going to happen. But it is a good idea to print off the contracts terms cheat sheet that I sent you, or create your own little binder of notes. Can be very basic. So at least if somebody's throwing out some terms, you have an idea of what's going on. And if you ever really decide that contracts is something you really want to go into, feel free to reach out to me and I can help guide you at least a little bit in the right direction of getting to that point. All right, I hope you found this useful and good luck on your final. Please don't forget to reach out to me with any issues.